Hello, welcome to this session. What I am going to do, that I have got a lot of requests from the people that I should be talking about last year paper solution, right? But it is very tough to make all the solutions. So what I am going to do, that I am going to do it in part wise, right? So each week what I will do, I will take two sessions of 15-20 minutes each, in which I will discuss 4 to 5 questions. Okay, so by that way, in a month or so we will complete one, that is 2020 paper. Again, in next month we will complete 2019 paper, 18 paper, right? So in the next 4-5 months, I am trying to finish the whole paper, right? I cannot guarantee you, but at least I will try, right? Because last year also I started 2019 one, right? So I think I have discussed only 4 to 5 questions in that, right? 7 to 8 is left. That also I will complete, right? But since 2020 is there, I am discussing with 2020. Okay, chale, then let us start with that. Then question number 1, right, actually says that the goal specified in the preamble contains the basic structure of the Constitution, which cannot be amended under Article 368 of the Constitution. Analyze this statement in light of deciding cases, leading decided cases, right? So it is actually asking you that what do you mean by basic structure, right? Do you know basic structure or not, and how that basic structure, the component of basic structure is found in preamble. Okay, so how will you approach this particular answer, right? It is actually intermixing of two varied concepts. I told you in the test series that there are sometimes question in which two concepts are interlinked. Okay, so that is one of them. Now if you look at the introduction part, what you will write, so you will write preamble in general, its major objective, right? What do you mean by preamble? What are its major objective, right? There's a model answer also, you will see there, right? Objective is to identify the source of authority, talk about certain benefit to the citizen, talk about sovereignty, secularism, etc. Then you will focus on the keywords, right, which is a part of basic structure, basically secularism or equality, okay, and rule of law, and thereby corollary to equality, rule of law. Then you will talk about basic structure in short, right? You will not go and write on all the case one and Bharti and every judgment in detail. You will hardly it should take 5 to 6 lines, right? Okay, started with Sankri Prasad, this was the question, and finally it was answered in the case one and Bharti, thus coming of this basic structure doctrine, right? Then you will write that how basic structure is a very abstract concept. Okay, now then you will point out through various judgments, right, that democratic form of government, secularism, how it is part of basic structure, which is also a part of preamble, right? So what you are doing actually in the conclusion part, you are writing that the basic structure doctrine along with the judgments which particularly held some specific words in preamble as the part of basic structure, right? So I have given here model answer also. This is the various your preamble options, not options, objectives, sorry. Then the doctrine of basic structure, see how nicely in very few words it have been written here. Then you will talk about preamble and basic structure, how they overlap, okay, and then you talk about multiple cases where certain part of the preamble have been held as a basic structure, right? How certain concept in the preamble have been held as a basic structure, not certain part of the constitution that have been held as a basic structure. Okay, so that is again a very simple concept. Now let us come to question number 1b, right? So there are 8 questions actually in a paper. So what I will do, that each week at least twice I will solve one question each week. In one question there are 3-4 subparts, right? So 4 to 5 questions in one video. So around 5 to 10 questions in a week, right? So it will take me around 1 month to complete one paper, right? So mains is far away, so hopefully I will be able to cover your paper of UPSC 2020 within 1 and 2 months, and then we will go to UPSC 19 paper. I will discuss all of them, right? I will make a separate this playlist where you can see these videos, okay? So that will be very helpful for you. Now let us come to question number 1b of 2020. It says, make a distinction between judicial review and judicial power, right? So very indirect question. What is the meaning of judicial review and what is the meaning of judicial power? Then explain the scope of judicial review with reference to cases arising under 10th schedule of the constitution, right, anti-defection law. Okay, so if we see that how do you write this question, you will first introduce the concept of judicial review and how you will write that how it is intrinsic part to our constitution. Then you will provide that how article 226 and 32 actually strengthen judicial review by providing writs, which is basically inherently a judicial review only. Okay, now what you will do that you will write that, then you will differentiate the meaning between two, right? If you look at the model answer, okay, that actually I have given a very specific paragraph that the judicial power is judiciary has the power to decide upon the legality of claim of conduct, to determine what the law is and what the right of parties are. Okay, judicial review on the other hand brings in the check the constitutionality of the legislative or executive power, right? Meaning that judicial review is basically when you exercise your role as a judge normally, right, determining disputes, etc., 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 playing as a judge. And judicial review, that is a judicial power, right? And within the framework of judicial power, or you can say slightly different, the concept of judicial review, that is actually inherently in the constitution, right? That is, I just told you with regard to writ, right? So that is the fundamental difference between these two, right? So that is the thing. Then in the last part you will talk about 10th schedule, and the best judgment of the 10th schedule is basically Quixote Holohan case, right, where the court talked about constitutionality of schedule 10th. Okay, so I've given in the model answer as well. Okay, now you may skip the exact provision of schedule 10, right? You can simply talk about, it talks about disqualification, and it was challenged in this particular case and Supreme Court held this. Okay, so that will be more than sufficient. You need not to go and write this paragraph, but I have given it, right, so that if you read it you should get some knowledge out of it. Okay, then this was question number, I think, 1B, right? Now there is a question number 1C. It is actually, I have repeated 1B, I suppose, here. Okay, now let us come to question number 1C. If you look at question number 1C, that talks about that says analyze the relevance of doctrine of eminent domain, right, under the constitution. Exact question I have asked, and this question have been repeated in 2017 also, right? Okay, discuss the doctrine of eminent domain and its relevance in India, right? I have another video also on that. Explain the limitation on its doctrine, limitations of this doctrine with help of case law. Very simple concept, right? How will you start with it? You will talk about eminent domain, right, or the principle on which the eminent domain is based, right? So if you look at the model answer, you will see that there are the two maxims, right? Populi supreme lex esto, welfare of the people is the paramount law, and necessita public measure est quam. Okay, private necessary is lesser than the public necessary, or public necessary is the more than the private necessary. Okay, so that is the part. Then we will talk about the importance, right? We will talk about the importance. Okay, now what will you talk about the importance, right? So in the case of importance, what you will do actually is that you will say that how in country like India, right, where the land rights are there obviously, but those land rights are not as good as normally it should have, it should be, right? So in those cases this doctrine becomes quite relevant in India today, right? But you will write that this doctrine should not be used for the purpose of transferring private property through public functionary to the private another individual. Okay, you acquire land, right, that it is for public purpose, and later on you sell it to a money. That should not happen, right? So it means there has to be some limitations on that particular doctrine. Okay, so that limitations we have talked about. Now the most important case about that limitation is Reddy versus Collector Rangareddy district. The court held that it is subject to judicial review on ground of these 4 grounds. Okay, malified exercise of power, a public purpose is not only apparently for public purpose or private also, right, without procedural violation is there, unreasonable, irrational, okay, and the last is not for public purpose, right? It is trying to play fraud, saying it is public purpose but basically it is for private purpose. Okay, so those are the limitations. Then we will come to the D1D question, right? It says the enumerate list of fundamental duties provided in the constitution and write the rationale behind it. Very such an easy question, right? So what you have to do, you have to first list all the duties. I have not written here all the duties because you all know what the duties are. Read article, part 4A and write all the duties. The rationale is actually here important. Okay. Now if you look at it, there are three major rationales that are there for the providing of this fundamental duties. The first rationale is intended to serve as a constant reminder. People should remember that there is a fundamental duty, right? Second, to help promote the spirit of brotherhood, right? A spirit of patriotism. And the last was, to remind of the moral obligation, right? To remind of the moral obligation to the citizens of India, right? So they are the three major objectives. Again, very easiest question. Now 1E, that is a little bit, good question. What are the various modes of judicial control on delegated legislation? How will you approach it? You first write about delegated legislation and how it needs to be controlled, because there is an inherent flaw in delegated legislation. It is not a legislation which the legislature had the opportunity to apply their mind. Okay, even though there are some parliamentary control, but that also happens in a very mechanical way, right? So again, that is not here. Okay, so that you will talk about. Then you will talk about the methods. That is what you will write in the beginning. Then you will talk about methods through which the judiciary can control it, right? So here I have given, along with the case law, it is written, right? So here I have given, what are the ground, not exactly the method. The method is only one, that is judicial review. So basically, ground, on which judiciary can control it, right? So basically, it should not be unconstitutional. The statute from it derived should not be unconstitutional. That is the first ground. Okay. Second ground, that the subordinate legislation or delegated legislation should not violate the constitution. And third, it should not violate the parent act itself, right? Purpose of the parent act itself, right? So these are the three major grounds through which judiciary can control delegated legislation. There is one more ground, that there should not be excessive delegation. Okay, the primary function of the judiciary legislature is to delegate, right? So it cannot delegate that primary function to the judiciary, to the executive. Okay, so that is also one of the grounds that also you can talk about. Okay, so I have given cases also here, right? So it is a very simple question. Talk about judicial meaning of delegated legislation, why it needs to be checked, and then how judiciary can check it through various methods. So basically various ground on which the delegated methods can be checked. Okay, then it can be further divided into substantive and procedural part also, right? But leave that, just out the various modes through which it can be checked. Okay, thank you.